Hi, I'm Dal Sagiar, accredited claims agent at Chisholm and Kilpatrick. I'm here with Mike Lestrito, managing attorney. So, not all veterans realize that you can appeal a VA decision in court, but there is, in fact, a federal court dedicated to veterans appeals. This is the United States Court of Appeals for Veterans Claims, or as we'll say in this video, the CAVC. Today, we're going to talk about when and how you fight VA in court. So, Mike, can you tell us what the first step is?
Yeah, well, first, the veteran needs to have exhausted all of their administrative appeal options within the VA system. That typically means that you have to have a final decision from the Board of Veterans Appeals, or BVA as it's known. Keep in mind that in this context, a final decision means either a grant, partial grant, or a denial, not a remand. A remand is not considered a final decision for these purposes. At that point, assuming the appeal is in the new AMA appeal system, veterans will have the choice to file either a supplemental claim at the regional office or, as relevant for this video here, an appeal to the court. If the veteran decides to appeal to the CAVC, they will have 120 days from the date of the board decision to file the notice of appeal. And that needs to be filed specifically with the court, with the CAVC, not with VA, as other appeals typically are required to be filed.
Great, right. So, how would you prepare your case to go to the court?
I think right off the bat, it's important to understand that appeals before the court do not allow for new evidence to be submitted, as is the case for appeals before the regional office. It's a closed record, in other words. The CAVC is a judicial review court, which means that their only role really is to review the findings of the board of the VA and determine whether there was a legal error made in applying the law. The court will review the existing evidence and determine if there were legal errors in the board decision, and if there were, then they'll remand back to the board to readjudicate the case.
Okay, great. And so, what about these oral arguments? Do the veterans or their attorneys need to go to the court to argue their case?
Yeah, so oral arguments are not actually routinely held in every CAVC case. Most of the arguing is done through legal brief writing. Parties can request an oral argument if they choose to do so, but the judge is the person who ultimately decides to either grant the oral argument based on whether they believe it will be helpful in reaching a decision. This is, again, rarely actually granted. So most cases never have an actual oral argument in their case before the court. Cases with novel legal questions are much more likely to be granted an oral argument. Typically, the CAVC will just make a decision, as we said, based on the veteran's claim and the appeal file and any briefs that are submitted, legal briefs that are submitted to the court.
So, this leads into my next question. What kind of decisions can the court make?
So the CAVC will make one of the following decisions. They will, as we said, remand the case back to the board with specific instructions, remand instructions, to correct the legal error that the court found. This is a very common type of decision that veterans receive, and this is what's considered a win at court. Of course, the court could decide to affirm the board decision, and that just means that after reviewing the case and all of the arguments that were submitted, the court agrees with what the board determined on the law. And finally, and probably the most rare of instances, the court can actually reverse the denial of the claim and directly grant benefits. As we said earlier, a win at court typically looks like a remand for the veteran, where the court sends the case back to the board to be readjudicated again, and direct benefits are granted. But in this rare instance, when a reversal is granted, the court actually will reverse the findings of the board and grant benefits right then and there.
Right. So, if the court does reaffirm the board's decision and you disagree with that, what are your options?
There still are some options. So if you disagree with the court's decision, you can, or the veteran can, file a supplemental claim if, again, the appeal is within the new AMA appeal system, and that needs to be done within 1 year of the CAVC decision. Or appeal to the U.S. Court of Appeals for the Federal Circuit, and that must be done within 60 days of the date of the court decision. If the Federal Circuit denies your request or you disagree with their decision, there is one final option, and that is to appeal to the Supreme Court of the United States. I will caution that this is something that is rarely granted. The Supreme Court has the ability to grant or not take the case. Um, and as often happens, the Supreme Court will not take the case. And so, although it is an option, I wouldn't hang your hat, so to speak, on the ability to appeal your case to court. That said, though, there was one case decided just last term by the Supreme Court that involved a veterans case. And so it is possible, but, I think full transparency, it's not something that's often granted at the Supreme Court.
Right. Okay. Do we have any tips for someone considering a court appeal?
Yeah, so I would say hiring an experienced veterans law attorney is a very good idea. And the reason for that is there are numerous new and existing procedures and case law that one has to be aware of to have a successful court appeal. Even many VA accredited representatives don't have the requisite court experience to take a case from the board and successfully appeal it at court. CCK law is actually unusual in that we've been to the CAVC on behalf of over 15,000 veterans. We've been able to help define veterans law for 25 years, and a lot of the most precedent-setting cases were actually argued by our firm here. Also keep in mind that, if a veteran wins, they typically get a remand at court. And as we said before, that doesn't automatically lead to a grant of benefits. It allows for, or requires rather, the board to re-adjudicate the case, applying or correcting whatever errors the court identified in its initial decision.
So speaking of, monetary implications here, how much does an appeal to the court cost?
Yeah, so the good news for veterans is that outside of minimal filing fees, usually around $50 or so, veterans typically don't have to pay anything out of pocket for a court appeal. Representatives are reimbursed through what's known as the Equal Access to Justice Act, or EJA. And that allows for attorneys or accredited representatives representing a veteran at court to be reimbursed for their legal fees through the federal government. And so, nothing out of pocket from the veteran is typically required, and that's great news. They can have representation at court where, again, as we said before, the issues can be pretty complex. There's constantly changing case law. And frankly, the rules at court, the procedural rules at court are much different than those at the regional office.
Exactly. So this is a really complex topic, so that's where we're going to stop for today. But if you'd like to hear more, please let us know in the comments. And if you're considering an appeal to the CAVC, contact CCK Law. You can get a free case evaluation from us. And don't forget to like and subscribe. Take care.